Good morning. Hey, this is Wes Bailey here, and I am starting the second part of what has been a discussion on successions, and this one is about successions with a will. Now, if you have a succession or you need a succession, which is the transferring of property from one person that is deceased to their estate, which is usually family or friends, or it could be anyone, it could be a company or a trust or a charity or a church. This is the commentary on, do they have a will? And the first thing you have to ask yourself is do they have a will, and is that will legitimate? So I'm going to read over what is the requirements for a goodwill, not the store, not the store at all, a goodwill, which is a notarial will in Louisiana. So the first thing you need to have is it has to be typed, and the testator can read it and sign his or her name. In that case, the person that's the testator, which is the person signing, the person that's whose will it is, they're going to sign the will on each page. They're going to sign the will at the end. They're going to do all of the signing of that will in front of a notary, and on top of that, they're going to do it in front of two witnesses. Now, the two witnesses is important because they cannot be witnesses that are the notary. It has to be completely different than the notary. And they got to declare or signify to the notary and the two competent witnesses that the instrument is his testament. Okay, and that's what we normally call a notarial will. Okay, a notarial act for a will. So what you want to do is you want to definitely just have that done normally with an attorney. Notaries do them as well. I've seen that done as well. But also you want to make sure that that's done in proper form, because if it isn't, if it's out of form, then the laws shift to a non-testament succession. That means no will exists if it's bad form, and that gets challenged in court. So be mindful of that. There are other types of wills. People call them handwritten wills, or the lawyers call them holographic wills. And we'll get into that for another discussion and what the requirements are. But the same things are required for a will that you need to have for a notarial act. Two competent witnesses, a notary, anything that's going to be notarized. Okay, so give us a call if you need something like that. We're happy to help. It's 337-404-7716, and we appreciate you. Bye-bye.